Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
So, welcome to another episode of the Employee Survival Guide. I want you to just imagine this scenario for a second. You've just signed the closing papers on your brand new home in Houston.
Right.
All your moving boxes are packed. They're stacked up in the living room of the St. Louis house you just sold. You have completely uprooted your entire financial life and your physical location. And it's all because your employer, this company you've loyally served for 42 years, they explicitly approved your transfer to a new city.
Yeah, you're totally ready for the next chapter.
Exactly. But then you check your inbox. There's just this short email from management. The transfer has been canceled.
Oh, yeah.
No real explanation. The offer is just gone. And because your old house is sold, you obviously can't stay. So you are suddenly jobless, houseless, and about to lose your health insurance.
I mean, it is a genuinely terrifying position to be in. It's that exact moment when the solid foundation of a lifelong career just completely evaporates under your feet.
And that visceral, catastrophic moment is really the focus of our deep dive into the source material today.
Yeah.
We're unpacking this high-stakes standoff between a massive corporate entity and a highly courageous 42-year veteran employee who is actually fighting back.
Which is pretty rare, honestly.
It is. We're looking at what happens when workplace rights just violently collide with corporate bureaucracy and the intense legal battles that erupt when an approved lateral transfer is yanked away at the absolute worst possible time.
So, to guide you through this, we actually have a really fascinating stack of primary source documents. We are examining the actual court filings from a pro se plaintiff.
And pro se, just a quick reminder, means she's representing herself in federal court without a lawyer. Right?
Yes, exactly. It's a huge undertaking.
Yeah.
Her name is Frostie Ellis-Yancey, and she is suing her former employer, Midwest Block and Brick, which is a quickcrete company. And to really understand the legal maneuvers happening in this docket, we're also analyzing two major legal precedents alongside her case. The first is an older, historically rigid Eighth Circuit case on constructive discharge called Onda v. Wicks Furniture.
Okay.
And the second is a brand new, just absolute game changer of a United States Supreme Court ruling called Muldrow v. City of St. Louis.
Now, before we really get into the weeds of these documents, we do need to state very clearly for you that these sources contain allegations and ongoing legal arguments.
Right, absolutely.
We're not taking sides in this litigation, nor are we endorsing any specific viewpoints, political or otherwise, of the parties involved. Our mission today is simply to impartially report on the ideas, the claims, and the defenses contained in the original source material.
Yeah, we just want to help you understand the underlying mechanics of employment law and how these really complex corporate disputes actually play out in real life.
Because that context is so crucial here. The facts alleged in this docket are they're incredibly stark. Let's look at the plaintiff's own filing, which is called a more definite statement.
And this document paints a picture of just extreme loyalty. Like, the plaintiff was born in 1958. She spent 42 years working for Midwest Block and Brick.
42 years.
I know. To put that in perspective, that is over 4 decades of continuous employment at the exact same company.
Right. She started working there when some of her current managers were probably in elementary school. But in 2024, she decides she's ready for a perfectly normal life transition. She wants to relocate to Houston to be closer to her family, specifically her granddaughter.
Which makes total sense.
Yeah. And according to the filings, she does everything by the book. In January of 2024, she talks to her St. Louis manager, Mike Hewlin, and he's highly supportive of the idea. She discovers there's an open position in Houston for the exact same job she already performs in St. Louis.
So it's a lateral transfer. I mean, she is not asking for a promotion. She's not asking for a raise. She literally just wants to change the geographic location of the desk she sits at.
Exactly.
And in May of 2024, she has a team interview with the Houston office. The interview is successful. And then, and this is the crucial part, her filings state that the transfer is explicitly approved. Management gives her the green light to make the move.
And this is exactly where the dominoes start falling.
Yeah.
Because she's relying entirely on that corporate approval, she makes massive, irreversible life decisions.
Right.
She sells her home in St. Louis. She turns around and buys a new home in Houston. She has physically and financially committed herself to this transition entirely based on her employer's word.
Yes.
But then on June 13th, she receives an email from the Houston manager, and the message is completely jarring. Management has suddenly denied the transfer. They just pulled the offer.
And the timing is just devastating. Management rejected the transfer only after she had sold her house.
Right, when she's totally exposed.
Exactly. And the cascading consequences for her are just severe. She can't simply, shrug her shoulders and show up to her old desk in St. Louis on Monday morning because she no longer has a home there. The company's reversal effectively leaves her without a job.
Which means she loses her health insurance.
Precisely. And the documents note that she suffers from an autoimmune disease, which makes the loss of health coverage a critical, life-threatening emergency.
Oh, wow.
Yeah. She's forced onto Medicare early, she's forced to burn through her accumulated paid time off, and she has to take early penalized withdrawals from her 401k just to keep her head above water until her late husband's Social Security benefits kick in. I mean, it's total financial destabilization.
And here's where it gets really interesting. In her definite statement, she doesn't just outline the financial ruin. She actually includes a smoking gun allegation about why this happened.
This part is wild.
She states that a witness, a former human resources representative named Casey Christoph, told her the actual reason corporate killed the transfer. This HR rep allegedly overheard comments from management revealing that once they realized who was applying for the Houston job, they assumed she would be retiring soon because of her age.
Right.
Therefore, they allegedly preferred to give the Houston position to a younger person.
And that detail is basically the hinge of her entire legal claim. Because the plaintiff makes it abundantly clear in her filings, she never had any intention of retiring.
Never. She just wanted to move.
She simply wanted to transfer to Houston, be near her family, and continue doing the exact same job she had successfully done for 42 years. But management allegedly made this discriminatory assumption based entirely on her age, overriding an approved transfer just to bring in a younger candidate.
And I have to point out the dark irony in her filing. That younger person they supposedly brought in from Dallas to take the Houston job, that person ended up quitting just a few months later anyway.
Yeah, it adds this whole other layer of frustration to the entire ordeal, absolutely.
So this brings us to the core tension of our analysis today. If you're the plaintiff and you had an approved transfer, you sold your house, and then the company deliberately pulled the rug out from under you, effectively forcing you to quit, how on earth does a team of corporate defense lawyers try to defend against that?
Right.
How do they argue they did nothing legally wrong?
Well, that requires us to dive into the procedural mechanics of employment law, specifically this concept called constructive discharge.
Okay, let's hear it.
When we look at the defendant's renewed motion to dismiss, which was filed by this prominent management side law firm, Fisher and Phillips, we see a fascinating, strictly procedural defense. They aren't really arguing about who said what. Instead, they're filing what called a Rule 12b-6 motion.
And what does that mean in plain English?
They're essentially telling the judge, Your Honor, even if every single fact this pro se plaintiff alleges is true, the law says she still loses.
Okay, let's unpack this. They're basically arguing that even if they ruined her life, it isn't illegal. How does that logic work under the Age Discrimination in Employment Act?
Their argument hinges on the definition of an adverse employment action. The defense lawyers argue that denying a lateral transfer, meaning a move to the exact same position with the same pay and the same rank, does not legally qualify as an adverse employment action.
Wait, really?
Yes. Because her paycheck in Houston would have been exactly the same as her paycheck in St. Louis, they claim she suffered no recognizable legal injury when they canceled it.
I want to make sure I understand the mechanism here. Are they utilizing a sort of like a landlord-tenant logic? Like if my landlord decides to paint the hallway of my apartment building a hideous neon green color, I might hate it. It might ruin my day.
Sure.
But I still have an apartment with the exact same square footage and the same rent, so I can't sue the landlord for an illegal eviction. Is the defense basically saying, hey, we just denied a desk change, her paycheck was never threatened, so technically we haven't harmed her?
That is an excellent analogy for how the courts have historically viewed this issue. To understand why the defense feels so confident making that argument, we have to look at the older precedent they're relying on. Specifically, that Eighth Circuit Court of Appeals case, Onda v. Wicks Furniture.
And the Eighth Circuit is the federal appellate court that covers Missouri, right? So its rulings are binding law in this jurisdiction.
Correct. And historically, the Eighth Circuit set a notoriously high, almost impossible bar for proving constructive discharge.
And just to clarify for everyone listening, constructive discharge is the legal term for when a company doesn't officially fire you, but they deliberately make your working conditions so impossible or alter your circumstances so drastically that any reasonable person would be forced to resign.
Yes, exactly. So in the Alonda case, the Eighth Circuit ruled that to successfully claim constructive discharge, a plaintiff has to pass this brutal two-pronged test. First, you have to prove that a reasonable person would find the working conditions absolutely intolerable.
Okay, that makes sense.
But second, and this is where most cases go to die, you have to prove that the employer explicitly intended to force you to quit. It isn't enough that the conditions were bad. You have to prove the company designed them to be bad specifically to get rid of you.
And the employee also has to give the employer a reasonable opportunity to fix the problem before resigning.
Right. Right. So in our current case, the employer is leaning heavily on that historical standard. They're citing older Eighth Circuit cases like Lepeque and Spears, which established this really firm employer-friendly rule.
Which was what, exactly?
Those older cases said that a transfer involving only minor changes in working conditions with no reduction in pay or benefits does not constitute a material employment disadvantage. The underlying logic was that federal judges didn't want to become like super personnel departments. They didn't want to micromanage every single shift change or departmental transfer inside an American corporation.
Wow. You know, when Fisher and Phillips filed this motion, they weren't just arguing against Frosty. They were utilizing a playbook that impacts everyone listening.
Oh, absolutely.
Because if you've ever requested a shift change to be able to pick your kids up from school or ask for a location transfer to shorten a brutal commute, you need to realize that corporate defense lawyers have historically viewed the denial of those requests as legally meaningless. As long as your title and your salary remained untouched, the law essentially said your employer could do whatever they wanted, and you had no grounds to sue for discrimination.
Yeah, that has been the impregnable fortress of corporate defense for decades. Like, no change in pay equals no adverse action. But as ironclad as that sounds, based on the history of the Eighth Circuit, the source material reveals a massive, glaring omission in the employer's current legal filing.
Oh, I know where you're going with this.
They have completely ignored a recent ruling that fractures their entire defense.
Yes. When you read through the employer's second motion to dismiss, they completely fail to mention a United States Supreme Court case called Muldrow v. City of St. Louis.
They just don't bring it up.
And I have to ask you about the strategy here. How does a team of sophisticated corporate lawyers file a motion to dismiss in a Missouri federal court arguing about transfer law and fail even mention a Supreme Court case about transfers that literally originated in Missouri? Are they banking on the fact that the plaintiff is pro se and hoping she just won't notice?
Honestly, it's a staggering omission. Whether it's a calculated gamble or strategic blindness or just a genuine oversight, ignoring a controlling Supreme Court precedent is incredibly dangerous. What's fascinating here is what the Muldrow case actually dictates and why it acts as a wrecking ball to the employer's whole no harm, no foul defense strategy.
So we really need to break down who Sergeant Chitonia Muldrow is, because her story is incredible. She was a police officer for the city of St. Louis.
Right.
And for almost a decade, from 2008 to 2017, she worked in this highly prestigious specialized intelligence division. We are talking about investigating public corruption, overseeing the gang unit, coordinating with federal agencies. She even had FBI credentials and an unmarked take-home vehicle. Her outgoing commander literally referred to her as a workhorse.
She was operating at the absolute pinnacle of her department. But then a new commander takes over the intelligence division, and he decides he wants to transfer Sergeant Muldrow out of the unit because he wants to replace her with a male police officer.
Just flat out.
Yeah. He stated that a man was a better fit for the, quote, very dangerous work they were doing.
So he essentially transfers her out strictly based on her sex. She's moved to a uniformed patrol job in a completely different district.
But here's a critical mechanical detail of that case. When they transferred her to uniform patrol, her rank remained exactly the same and her pay remained exactly the same. It was, on paper, a perfect lateral transfer.
But the reality of her day-to-day life was completely downgraded. She lost her FBI status. She lost her unmarked take-home car. And instead of a predictable Monday through Friday administrative schedule, she was suddenly working a rotating schedule that included weekend shifts.
Exactly. So she sued for sex discrimination. And when her case went through the lower courts, including that same Eighth Circuit Court of Appeals we discussed earlier, the judges threw her case out.
Using the old logic.
Right. They use the exact same logic that Fisher and Phillips is currently using against Frosty. The Eighth Circuit looked at Sergeant Muldrow and said, well, your pay didn't change, your rank didn't change, therefore, you haven't suffered a materially significant disadvantage. Case dismissed.
But she didn't stop there. She appealed it all the way to the United States Supreme Court. And the Supreme Court completely dismantled the Eighth Circuit's logic. Justice Elena Kagan wrote the opinion, and she approached it with strict textualism.
She looked at the actual plain text of the statute. Now, here's a crucial technical point we need to clarify for the listener because it bridges these two cases together perfectly.
Okay, let's hear it.
Sergeant Muldrow sued under Title VII of the Civil Rights Act, which covers sex discrimination. Frosty is suing under the Age Discrimination in Employment Act, or the ADEA, but both of those federal laws use identical statutory language. They both make it unlawful to discriminate against an individual with respect to the terms, conditions, or privileges of employment.
Right.
So because the language is identical, when the Supreme Court interprets Title VII, it effectively rewrites the rules for the ADEA as well.
That makes perfect sense. So Justice Kagan looks at the phrase discriminate against, and she rules that to discriminate against someone simply means to treat them worse. The statute does not say you have to treat them significantly worse or materially worse. The Supreme Court ruled that a plaintiff only needs to show some harm regarding a term or condition of employment. The lower courts had basically spent decades inventing a heightened standard, this whole material disadvantage hurdle that simply did not exist in the text of the law.
And so the Supreme Court vacated the Eighth Circuit's ruling. And if we synthesize that Muldrow precedent with our current case, the implications are just profound. Under Muldrow, the threshold for proving harm is drastically lowered. The employer can no longer hide behind the fact that the St. Louis job and the Houston job paid the identical salary.
Because if we apply some harm standard to Frosty, the harm is massive. Look at the chain of causality. She was denied a transfer she had already been approved for.
Right.
This denial happened after she sold her house in St. Louis and after she bought a new one in Houston in reliance on the company's approval. The cancellation directly triggered the loss of her employment, which triggered the loss of her health insurance, forcing a woman with an autoimmune disease onto Medicare and draining her retirement accounts.
It's unbelievable.
I mean, if Sergeant Muldrow losing a take-home car and getting weekend shifts qualifies as some harm, then losing your home and your health insurance unquestionably qualifies.
The causality is the key. We are watching a fascinating strategic clash in these legal documents because the reality of the situation is that the employer constructively discharged the plaintiff. By canceling an approved transfer at the absolute last minute, knowing full well she had already executed cross-country real estate transactions, they knew she would likely have no choice but to quit.
Yeah, they had to know.
But legally, in their filings, the employer is still pretending the old rules apply. They're banking on the judge, demanding a material employment disadvantage based on her paycheck.
But the landscape has completely shifted beneath them. Under the new rules established by the Supreme Court, Frosty's experience easily meets the some harm threshold. The days of corporate lawyers chanting, no harm, no foul, just because the salary stayed the same, are officially over. Because if the decision to revoke that transfer was made because of her age, as the HR witness allegedly overheard, then under Muldrow, it is actionable discrimination.
It completely redefines the battlefield. The Supreme Court has made it unambiguously clear that transferring an employee, or as in this case, discriminatorily denying a promised transfer, fundamentally alters the terms and conditions of employment.
So what does this all mean for you? We have covered a tremendous amount of legal machinery today, but at its core, this is a story about a loyal, 42-year veteran employee caught in a devastating administrative reversal.
Right.
We've examined the historical, incredibly high bar that used to protect employers from constructive discharge claims.
Yeah.
And we've analyzed a corporate legal defense that seemingly ignores the newest, most vital Supreme Court precedent that just lowered the threshold of injury to some harm.
And it's a stark reminder of how rapidly employment law evolves, and why relying on decades-old precedent is just a dangerous game when the Supreme Court has recently spoken.
And to bring this directly back to your own life and your own career, the landscape of workplace transfers and anti-discrimination law is actively shifting. The days of your employer arguing, your pay didn't change, you can't sue, are facing intense, unforgiving scrutiny.
Totally.
If you are ever navigating a corporate relocation, a shift change, or a role transfer, This docket is absolute proof that you must protect yourself. Get everything in writing. Do not list your house. Do not sign a new lease. Do not pack a single box until you have a final, legally binding, unwithdrawable offer letter in hand.
That is so important.
Because as we have seen, verbal approvals and successful team interviews will not pay your mortgage if corporate management suddenly changes their mind.
That is the ultimate practical takeaway for anyone navigating the corporate world today. But if we connect this to the bigger picture, there is one final lingering detail in the source material that we haven't fully explored, and it involves the systemic role of human resources.
Oh, right, the emails.
Yeah. The documents show that after Frosty's life was completely upended, after she had lost her home and her transfer was canceled, she sent desperate emails to an HR representative named Dahlia Chavez, begging for an update, an explanation, or a solution.
And what was the response from HR?
Total, absolute silence. She was completely ghosted by the department that is theoretically designed to manage employee relations.
That is just wow.
And it raises an important question for you to mull over. When a massive company's internal dispute resolution mechanism simply ignores an employee of 42 years who is in the middle of a manufactured life crisis, is that silence just an unfortunate administrative failure? Or is the silence itself a deliberate corporate strategy, like a calculated legal tactic designed to isolate the employee and force a resignation without leaving a paper trail?
It really makes you wonder who human resources is actually protecting. At the beginning of this analysis, we talked about a career being a contract, a solid foundation you build your life on. But as Frosty's story shows, sometimes that foundation is only as solid as the legal paperwork backing it up. Because when a company decides it's time for you to go, they really don't care how many boxes you've already packed.
No, they certainly don't.
Thank you for joining us for this deep dive into the source material. Stay informed, get everything in writing, and we'll see you next time.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.